I'll be honest, we're not in charge of stuff. And it's hard because, okay, so we give you these cases, but you're not an attorney. We always say the man who represents himself as a fool for a client, right? That's a famous sort of adage. And it's hard because sometimes these guys can't afford, so I don't want to make light of that. The honest to God truth is that we're just not focused on that. And we could, right? But we are focused on, frankly, being a startup company and making revenue and things like that. But the technology we're building could certainly be made available, not just to civil rights attorneys, but to pro se litigants as well.
For Brian, would you use AI in that context where you have a non-well-off person and they want to see what they can do? Just type in like this scenario and then have some kind of pop-up show where the case law would be good for them and see if they actually stand a chance, and maybe you allow them to represent themselves.
Imagine these cartridges again, trained by experts in, say, domestic violence law, given some pro bono hours, donated some pro bono hours to this effort, so that a cartridge would begin to reason like domestic violence lawyer in that given jurisdiction, and someone could ask, what are my legal rights? Do I have any legal rights? And they could freeform explain their scenario, and the system would understand two different people explain the scenario, similar scenario, two different ways, what they mean, what their intent is, and then put forth recommendations. Yes.
Lastly, they'll run up against a wall, which is you're not allowed to practice law without a license.
Yeah.
And various states have been more or less aggressive about that, right? Going after like a legal Zoom or something like that.
I'm assuming that the laws will change to accompany AI.
Batman. Do you guys see more on the regulation side, AI being used by regulators to use, because we're seeing in financial services, energy space, things like blockchain and AI? Because
I think it's what you were saying about being able to test laws.
Well, being able to actually back test regulations and to see if regulations that are in place achieve the results that they were put in place to achieve, rather than winging it, rather than thinking based upon looking at one instance or two instances that we need this regulation. Critical in our approach to regulation, promulgating regulations. But another thing that we're doing is on the regulatory side, there are a whole other slew of Watson use cases for reading the unstructured data, reading the actual regulations, mapping them to controls dynamically. Yeah.
Batman, you better jump in.
What's that?
You better just jump in.
Oh, okay. When I was in law school 40 years ago, Lexis, brand new, and Westlaw didn't exist.
Not quite. Westlaw must have existed. It was founded in 1812.
No, West existed.
Oh, Westlaw. Okay, sorry. Leaving the electronic one. Okay, scary.
Okay, and when they first came out, they just had keynotes, no full text searching, because we're West. We were founded in 1880, and we know the books, right? So they had a bit of a tunnel vision, like most established companies. And for about 15 years, and then I was in business for about 15 years, selling to lawyers. We did fine, but I wouldn't wish it on most people. I was going to actually give Justice Holmes' quote there, but we tried some expert systems back in the 90s. And what is the essence of what you're doing now that's different from the failed efforts? I think that Watson must, in a sense, understand more natural language. But, the law is not the same in every state. The law changes from Congress to Congress. There is no overriding principle like in biology. There are lots of things that hang together. There are some legal principles come from contradictory sources and they don't agree with each other. In most cases they do, but the hard cases they don't. So could you tell me what's different now versus 25 years ago?
One, there's more data and more access to it to build machine learning and natural language processing algorithm models by far and away. And the efficacy of those models has increased more. But maybe we're not, so one of the reasons why we do more business with corporate law departments than law firms is kind of what you're touching upon.
Yes.
When we do meet with law firms, we will seek to what is your highest volume area of litigation, or which area drives the most revenue for the firm? We'll focus on that discrete area and build teach Watson the ontology of that particular practice area, rather than across everything. And then through user acceptance training, the end user will interrogate the system, validate the results. And the system is performing thousands of different calculations behind the scenes, and it's making leaps of judgment. And after a while, after the solution is validated, it takes 8 weeks or so, you can go live with it. I think is that we're taking a much more discrete approach, much more focused approach than we did in the past. We have access to more data, as I said, and there is more data, and we're able to do more with unstructured data, looking for concepts across documents, even documents that might not have anything on their face to do with each other, to look for non-obvious patterns and trends. But otherwise,
Okay.
you have to know what you're looking for beforehand with older machine learning models.
Yeah, because expert systems were very brittle in some sense.
Yeah, and they're rules-based. 1 + 1 = 2.
Right.
With true with the ability to do a lot with natural language understanding, as we call it, you can potentially preserve your rules, preserve your decision tree, but fit more into that tree because you understand that this is more appropriately slotted here and this is more appropriately slotted here. A much less brittle system.
I'd be interested in seeing it. I happen to be listening to George Lakoff on the way over here, and I'm skeptical about machines understanding things in the way that humans do, and I don't know that Watson tries to do it the same way. I suspect it doesn't, but I think there's a fundamental problem about cognition.
Absolutely.
I mean, Terra doesn't understand anything. It doesn't.
Yeah.
And the fabric that does unify, the thing we can find 200 years ago was judges citing to precedent, right? And even certain patterns, like the phrase, "it is well settled," which is this really unique phrase that means we're not going to fight about whatever comes after what I'm about to say. And so it's survived not just hundreds of thousands of times, but you go all the way back to like when the S's were F's, and it's like, "it is well settled," sort of. And you see this, no, it's an interesting concept, right? This little 4-word, 3 of which are stop words that you would almost throw away, right? Has survived and flourished and gone everywhere, and you can see it. So common law, there are these unifying threads that you can pull out. You're not understanding anything, right? You're just leveraging these patterns that are there, and I think that's a huge amount of power that we've been sort of just leaving on the table.
So it's really, is Watson basically pattern-based, would you say? Is it a highfalutin pattern matching?
In a sense, you want to know what you're looking for. You're not, hey, ask a random question.
Right.
Which is why we try to make sure business fit is really closely tailored. You know generally what you're looking for, even though it might be stated in many different ways. And so you show Watson ground truths representative of the concepts, the themes, the ideas, the goals, the information that you want. This is what duty looks like. This is what breach looks like. This is what causation and damages look like, the elements of the negligence cause of action. And then after a while, it will make leaps of judgment, say, okay, plaintiff met his burden of proof, or did not meet his burden of proof, theoretically. But you're building a model, of course. Yeah.
Yeah. Anyway, is it possible to see? You said something.
Just contact me. I'd be happy to give you a technical anything. Yes.
And just and even better, we've got a some sort of arrangement leading up to the event and with legal hackers for some amount of access to some of the APIs. So something that I wanted to offer is as part of the sort of weekly hangout that some of us are starting to do just in the Black Couch area in Sandy Pentland's lab as a discussion group. I think we should explore some of the Watson APIs at least one of those weeks and sit down and just roll our sleeves up. So not to the exclusion, if Brian Goodin's offering you like a technical walkthrough, don't miss it. But also we can just hack around a little bit and put some data in and do that. And if we have access to it as part of what we can do in the context of a class, and many of us would like to learn that. So that's an open offer. So anyone that wants to hack around on some of the APIs that have been made available to us, just say so after class, and then we'll make one of these weekly discussion groups just focused on that. And then a lot of other hands that were up.
There was a distinction between applying technology to the business versus the practice of law. And I'm curious about your guys' opinions of where's the law profession most amenable to applying technology to the practice of law?
That's what we were doing.
Yeah, so I think where you've seen pretty good progress was in e-discovery, right? So this would be, you know, in my day, we'd get literally boxes. I can't believe I get to say in my day now, but I guess they're there, right? You get literally boxes and boxes of all the emails, right? And you just go through them and flag them, right? Then you started to get, okay, just big, you know, hard drives with tons of documents, and you go one at a time, right? And you'd see things like every Tuesday morning at 8 a.m., it's an email from ESPN with the same subject line. And you'd be like, dude, can I please? I'm just gonna batch tag these, all right? I'm just gonna filter them all out, and and they'd be like, don't be a cowboy, Pablo. And I'm like, you know. So, and you can imagine how inefficient this was, right? And just how terrible, this soul-suckingly terrible that was. So now, okay, well, they'll say, okay, we'll just review 10,000 documents, and the coding, you know, the machine will say, I get it, if I see these or that word, right? So in discovery, I've been kind of impressed with lawyers. They kind of took it on, did it. Judges sort of signed off on it. So that's an area where I think they've been pretty. Research, they have a ways to go. Research has been a lot trickier because they've been using See, they don't use e-discovery tools in law school, right? No one teaches you e-discovery in law school. So they come out and they don't know. You know, Westlaw they've been using since they were first-year law students. So it's really sort of ingrained in them to sort of use that. Other areas where they've been doing tech.
A lot to do with M&A due diligence.
Oh yeah,
and a lot to do with transactional law generally. But M&A due diligence has been very, very ripe for various AI startups as an area of focus.
Upload a contract and we'll tell you if this clause is different than the other 50,000.
I was intrigued by Brian's last bullet, which spoke about the meaning of law, which you didn't really unpack. So I'll ask this question quickly for both of you. It was at MIT Media Lab in 2014, where I was really impressed with who were having a thoughtful conversation about the ethics of coding. Never really seen that, and it seemed like they were kind of figuring it out as they went along. When I was in law school in South Africa, law was respected. Nelson Mandela was a lawyer. Law was respected often as a barrier, a protection against the underprivileged or the downtrodden. So law is esteemed in many ways, although it can be abused. Do you see any problems in the ethics of what your powerful weapon / widget is developing in the practice of law that sits so carefully on the relationships between humans and institutions?
I do. One would be judges training expert systems. Those expert systems inheriting the biases of those judges on the one hand. But if you think about it another way, those expert systems could be used as mirrors to reveal to judges, to reveal to us what our biases are to begin with, and then we can act accordingly. But if we don't do that, then yes, I think that's something that first thought that came to my head.
I would say absolutely. So you mentioned before there was Westlaw with West, you would use their key topics, right? So Westlaw over a century had split all the cases up into their different categories. And those categories, you were basically a prisoner of their taxonomy. That became how lawyers thought about the law. There's a great paper, I think, by Bob Baring on this. So then key search came along and suddenly we're free, right? We can now just type where we go and we're off, and there's problems with that as well. Now here we are saying, no, let the AI sort of guide you, right, and tell you. And if you type a keyword, sure, but we'll let the AI kind of contribute too. So are we re-imprisoning you now in what we think the law is, right? It's a real problem, right? You want, like a kayak, you want different AI voices maybe, right? You want sort of hybrid vigor with different folks, and the other eye's like, that's a ridiculous case, you should read this one, right? Something to sort of diversify, right? Hopefully we'll make all of the different voices subscribe one at a time. No, I kid. But I think anything that's the interface between lawyers and the common law, there's a profound responsibility there, because that truly becomes then how the lawyer understands and kind of accesses the law.
Do you find that the model that case texts use of using these judicial opinions and links between documents works in some areas of laws better than others?
So I'd rather, instead of area of law or not, I want to talk about research in sort of two modes, right? So there's mode one legal research, is sort of the forest. You want to know what's the big governance standard, right? And there, the wisdom of the crowd does better, right? So for instance, if I want to invalidate your patent and say this patent is obvious, right? There's this leading case that the Supreme Court has that actually the fact pattern is about a gas pedal and a little electronic sensor on it. right? But even if I'm doing semiconductor research, I have to pay homage to that case because that's a sort of multi-factor test or, you know, the various things, right? Mode 1, the links work well, right? But mode 2 is where you say, I want the exact fact pattern that I have, right? And that's where the wisdom of the crowd actually pulls you away from what you want, unless you just happen to be doing exactly the same thing that the crowd case has. So I don't think that, I mean, I think that that network of precedent applies to all areas of law. I mean, if you have less case law, you know, certain little niche areas might have very few cases where perhaps there's sort of different factions there. But it's really something that spans all the different topics of law, sort of how we do it.
So I think we have time for one more question. We have about 5 minutes left.
Yes.
Yeah, I was wondering if you guys looked at maybe abstracting, you know, those machine learning stuff, typically the unsupervised kind, you kind of get abstracted from what the machine's actually doing at a certain point, and you stop understanding unless you do some like leave matrix and stuff, and more understanding that things like before, except that, well, there's certain cases where it's okay, but I'm wondering if you guys identified maybe any primitives that you might be willing to abstract from the kinds of texts and documents that you're reading that you maybe infer things like what's a neutral way of structuring different clauses or things like that, or just abstracting things in general and understanding really what the machine is say or what the machine is inferring from the documents it's reading.
So you're talking about sort of black box algorithms where you know it's doing something well, but it won't tell you exactly what word it's doing.
Sure.
I mean, like, all right, you know, I'm just sort of like, you got to make your peace with that because there's sort of, it's kind of ingrained in it, right? And I feel like sometimes it's like I could tell you if you'd like to read the 1,000,000 words in a list that I've used for this topic, and you're like, yeah, all right, like I'll read the first 5 and trust you that the rest are kind of. So I guess I'm not quite.
Well, yeah, I guess it's 2 questions. One is like about and then the other one is trying to find some kind of like truth, I suppose, amongst all the noise, I guess, that humans put into all of these language.
I haven't seen it. Have you?
What is truth? I
Yeah, no, it's never come out.
Yeah.
Sort of abstracted
Didn't go to Harvard.
that people can use to communicate these things in a way that's interpretable in very few ways.
So that sounds like some advanced sort of understanding stuff.
I'll throw out one thing, which is actors and actions. You know, like the rudiments, the primitive of a use case. In law, I would always look for where the roles of the parties and the transactions. Or in business, you know, something similar. So I've got a lot of mileage, you know, parsing through, I don't know how much data in the law, pulling out scenarios and being able to define the actors and actions and the parties and the transactions. And when you say the role, if it's like in Uber case, if you say that role is an employee, that tells you a lot. If you say the role is a contractor, it tells you a lot. As a consumer, it tells you a lot. So as soon as you can see a role and start to glom it onto an actor, and what kind of action was it? Going to work, slipping and falling a banana, whatever it is. That's the closest I've come. But I feel like through the lens of these new algorithms and a lot of data, through a social physics lens, we can begin to understand finally and see the contours of the law the first time.
You choose different primitives. So is a Uber driver like a DoorDash guy? Well, yeah, right? They're both summoned by the app to go and do something, right? But then you can on another level say, no, the guy's not chauffeuring you around. Like so what primitive you choose can change depending on your context. So I think efforts to sort of get that platonic, like this is what this thing is, are always going to be sort of fuzzied, if you will, sort of out of meaning by the next weird context. Oh, guys, this is so fun. I wish I could You guys have some really good questions. Thank you. Really love it.
So before Yost says a word, Brian and Pablo, you've given your email addresses. Is there a place that, 2 things. One, is there an ask you of people that they should understand your thoughts and what you're working on? And 2, is there a place on social media where they can sort of track where you're going to be speaking and what you're thinking about and what you're saying? So what to read/think about and where to find you on social media?
I would just say keep up exactly what you guys are doing. Take classes like this, go to these workshops that are being set up. It would be thrilling to have some of the absolute fantastic firepower of MIT and brought to bear on this tool. As you can see, we need a lot of help in law, so just keep it up is what I would say. And then follow on social media. I tweet at Pablo is my handle, so it's spelled out.
Right. For me, it's more LinkedIn. Just Google my name.
Can you post your emails on the website?
Yeah.
If you don't mind, you bet.
Awesome.
All right. Thank
you so much.
All right, thank you. So that's the end of today's class session with one important addition. That is to say, you all should have gotten an email from us, from me in particular, Yost, talking about what was happening today's session with the background links to our two guest speakers. If you did not get an email, please go to FutureLawMIT.org and click on the participant link, because that's the way to get on the class email list and for the upcoming weeks. And then we'll also be talking further about project possibilities and more. Any final questions?
Can I add something? Suck at people. If you got Yost's email from me, then you haven't done your job. You have to go get it directly from Yost, from iForward.
Through the sort of stellar class system. Those are the sort of keywords on top. Yes? Okay, good stuff. Thank you to our guests, and I'll see you all next week.
Okay. Thanks. FutureLawMIT.org for the class, and for the conference, it's MIT.edu/law.